Hi, chat. Wow, that is a fucked up story out in Idaho. Um, yeah, guys. I mean, you want to say a prayer for Aaron Murdoch, man? Say a prayer for him. That is fucked up what they're doing to him. That fucking weirdo kid comes in there to the fist fight, and he's just like looking back, looking back, looking back. All of a sudden, just blah 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 blah. Like fuck that guy. Fuck that guy. I hope that Taylor guy gets cornholed out for the next 30 years. I mean, Jesus Christ. Two guys start swinging, and this dude starts just turning into a bullet festival. Man, that's some fucked up shit. But anyways, guys, thank you for indulging me with that. Cannon's a great guy. Like I said, love him to death. He's met him, been talked to him a couple times. Talked with him on a bunch of future conflict. The best of the Hoteps, the greatest of the Hoteps, aside from Hotep Jesus. Better than Uncle Hotep, better than all the other Hoteps. So thank you guys. Yes, hail chat, hail Sean again. Yeah, sorry guys. Let's follow the story. Is the trial going to be streamed? I don't know, but I'm going to get a hold of all that stuff, and we're going to do a shit. We're going to do a show on that. We're going to do a separate show on that, and whether or not Dad could come on, we're gonna fucking watch that, man. We're gonna do that. Uncle's the best. Well, like I said, I like Cannon. Cannon's got a spot in my heart. There's Bubba Hotep. Yeah, there's all kinds of Hoteps. Been there, done that. Says, oh, you're welcome. I didn't know he'd DM me, so I was like, yeah. But guys, I appreciate you working with me on this real quick. And just because of that, hold on. Clyde! Come here, Bubba. Hi. Click, clack, click, clack, click, clacks. Come here. Hey. Hey. Hi. Oh. Yeah, whoa. Whoa, did you tell everybody what you did today? You got to go run around in the grass and your paws went green because of the grass getting caught. Huh? He's getting very protective of his bull penis that he's chewing on, too. Hi, Bob. What do you think, huh? What do you think? Huh? Huh? What? What's that? You got something you want to say? You got something you want to say? You look very pensive. You look very, very pensive, buddy. Come on, you could say it. You could say it. What's that? Yeah, yes. Free Palestine with the purchase of a Palestine of greater equal value. Yep. It really is a free Palestine, buddy. I'm not joking. They're giving them away. I told you. Emotion for Eleni emoji. Shit, we gotta get her stood still to take a picture. Sean's currently ranting. He'll be a minute. Bar complaint. It's a weird looking cat. So, hey, buddy, what you doing, huh? Come here. Do you want down? Clyde? Huh? Do you want down? You're not gonna give me any kisses? No. You got a bump right there. Man, I wish I had a bunch of lidocaines. I'd pop these bumps on you. All right, buddy, you went down. He's like, get me out of here, fat man. Okay. All right. I got you, buddy. I got you. There you go. No, go on. Hey. There you go. He's already got his bully sticks, guys. He's already got his bully sticks. He's down to cuddling mode. He's always looking. Well, he's kind of looking down in the corner, but he's always looking out the door. He's like, that's where 2.0 is. So. Is the Idaho DA a Soros anus? I don't know. Let's actually look that up while we're here. Bonneville County, Idaho. All right. Prosecutor. Let's see who this is. Let's see who this guy is. Randy Neal. There's no pictures. Just email addresses. Well, they got a lot of legal assistants for an office. Damn. Let's see if we can find a picture here. Oh, he kind of looks like the guy you'd think he would, the guy who's going to prosecute this. This guy definitely could put together a good charcuterie board for house guests late at night. Look at that face. Look at that face. He could definitely do it. You know what I'm saying. If you know what I'm saying. You know what I'm saying. All right, guys. So let's get into this. Let's get into this. Okay, the great Vincent Kennedy McMahon, the chairman of the World Wrestling Entertainment. You guys remember he had an issue with a former worker, Janelle Grant, and Janelle claims like she was trafficked. And, she got raped and they like to poop on her, but yet she kept coming back over. So it was like, are you guys going to promote me yet? Did I get the new job? Yes. 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 More cocks. All the black cocks. All of them. All the black cocks, Janelle. I want you to have all the black cocks. Well. So we did. Did they poop in her mouth? I don't know. They pooped in her hair, though. She's hell of a woman, honestly. Well, think about it, though. Vincent McMahon and Laurinaitis are like freaking digging her out on a routine basis. Like 75-year-old dudes just digging her out, man. That's impressive. That's the impressive stuff. You're really thinking about it. Yeah. I want to see you spit roasted by Junkyard Dog and Cook Cobware. I want to see Sergeant Slaughter and the Ultimate Warrior. So, it's just, Vince is half goat. Yeah. Coco Beware. That's what I thought, but I'm like, wait, did I read something? You phony fan. Well, it was written wrong. I was trying to I am an actor. I'm reading the prompts. Yeah, she was rotisserie, it sounds like. The Vince entrance theme is still my workout mix. It's fucking hilarious. So anyway, yeah, I know. Yes, I thank you, Eric, for like I said, I'm just reading as I go. Yes, Janelle is luckier than Andre the Giant's con. Oh, yeah. So what happened? Well, there have been some movements in the case, not bowel movements, but actual movements. So Sean Reed like Biden a teleprompter and Coco B last name. Well, it wasn't even the right order. That's why I messed it up. He didn't have it right. He didn't have it right. Yes, bring me Booker T and Kane. Oh, that'd be a rough one too. Where's the Big Show? Get me the Big Show. The Big Show and Brock. So let's get to this. What has happened? Well, a lot has happened. Oh, actually, wrong one. So this is by Vince McMahon, and he is ordering arbitration. The age-old devil of lawsuits and legal actions. Arbitration. And sometimes arbitration can be compelled. Pursuant to the Federal Arbitration Act, there are reasons why you can do this. So, how do we know that there's well, we don't have that here. We have to move to the next page or the next document. And this is a motion in support of arbitration. So there are times where if you have an arbitration agreement, you have to use that, and that's your mode of recourse. In arbitration, you sit down with an arbitrator, you sit down with a third party, and you basically try your case to him. You lay out all your problems, and you say, "Here's where I've been wronged. Here's what's happened. Here's what you should do." And Bella's saying, "Check Ryan Hall. What happened? Hmm, What happened? A tornado cast. Oh, Camelot's in the tornado. Um, Let me see. Hold on here. If you guys are in Tennessee, oh, I guess watch out. I don't see. They're not talking about anything right now. We'll come back to this in a second, I guess. Oh wow, God, that's a lot of red spots in Arkansas. Jeez. Yeah. All right, guys. Well, there's nothing here yet, so we'll come back to this in a minute. Till I hear anything. I can't even get it to load up. He's like, did Ryan Hall go down? Did the tornado get him? Because hmm, so we'll take a look at that later. They've been getting pounded all evening. Private message to me and X. Okay, hold on. Let's see here. All right, hold on, Pella. I'm gonna pull this up, see what you're saying. Oh, new footage of a damage of a tornado that hit. Oh wow, how bad was this? Oh wow, this place got wiped out. Man, we'll take a look at this real quick. Okay, guys, so this is Columbia, Tennessee. Jeez. Well, one house got wiped out. About the rest, woof. Wow. Wow. Dang. Sounds like, but wow. Jeez. Oh no. Hopefully no horses. Oh, the animals are out. Good. Didn't get squished. That's a lot of trees, though. Damn, chat. That's a lot of trees. There's a lot of trees. So be careful out there, guys. Be careful out there. Florence Dono says for $5. I'm at work in Tennessee on the second floor. It's so over. Oh, don't be that way. You still have a chance. Ohio's number 4 for most tornadoes so far in 2024. Yeah, we've had a lot. We've had a lot. Hmm. Yes, the pounding of Janelle is a great segue to the pounding of Tennessee. Yes. Please let John Bryan be all right. We cannot lose a civil rights lawyer. He's in West Virginia. He's safe. They don't get too many tornadoes out there. So Ohio's number 1 so far. Good. So, all right, guys. Well, so we're gonna move on here. Yeah, if you're out in Alabama, be careful, Huntsville. It does not look good. So, well, anyways, we're gonna keep going. So, what is we were talking about this for a second. What is arbitration actually? So, arbitration, you come down, you sit there with a party, you kind of present your stuff, and the other side presents what they have, and you explain. Basically, it's kind of like a mini trial. It's not the same. I mean, it's not a judge, so it doesn't work, and it basically functions that way. But they get to make a decision. It's like mediation in the same vein. Arbitration, though, generally is binding, meaning whatever results they come up to, you're stuck with. Guys, it's a very common thing in contracts. So if you see a lot of contracts out there where you sign them, especially like shrink wrap contracts, or if you click on the end user agreements for like video games or any of the stuff you buy out there, you generally speaking, if you want to sue, well, no, you got to do binding arbitration first. It's not uncommon at all to do it that way. Arbitration is BS at times, it can be, but at times it's not. Yeah, cell phone contracts, a lot of things are. And there's times where you can use that against them, and people have gamed the system against corporations because they bear the cost of the arbitration to put it on and host it. So you get a couple, yeah, 10, 20,000 people to do it. Well, it costs them a lot of money at that point. Couple $100 a pop, 20,000 times. Well, that's money companies understand. So what is Vince arguing here? He's arguing that there's a right to force Janelle Grant into arbitration. So the party and they talk about it, you'll see here. So how does this start? All right. Well, there is a statement here, and it's the Federal Arbitration Act, which is a real thing, and not the same FAA as the Aviation Administration, but yeah. So by publicly filing her salacious, false, and defamatory complaint, plaintiff has brazenly and intentionally violated a binding contract to arbitrate. The outrageous claims of sexual abuse and coercion are pure fiction, plainly intended to garner publicity, or flatly contradicted by plaintiff's own contemporaneous statements. Contrary to plaintiff's false allegations, plaintiff and defendant engaged in a consensual relationship during which the defendant never coerced the plaintiff into doing anything, never mistreated her. In fact, in a love letter plaintiff wrote to the defendant shortly before the parties ended their relationship, plaintiff described the defendant as my best friend, my love, my everything, praising her for being the wonderful, tender, vulnerable, heart on your sleeve, soul you really are. And he's like, yes, I am. It is incredulous that plaintiff, then a 42-year-old woman who claims on a resume to have a law degree from Pace University, would have written these words to a defendant months after all the events in the complaint alleged to have taken place. That's very true. Yes, she claims to have a law degree, but she worked from home for her sick parents. At the time, plaintiff was not dealing with grief and struggling financially as described, and she had been not devoting years to caring for her parents. Those are falsehoods. Um, Based on a foreclosure action against plaintiff and her parents, um, her dad passed away in 2017. Plaintiff met the defendant and his marital status was recorded as widowed, confirming plaintiff's mother had passed earlier. Oof. That's interesting. Records would show that contrary to claim around the clock caregiving, her dad lived in a senior care home in Stamford, Connecticut. Now, notice we are. This is a motion to compel arbitration. We're in a motion to compel arbitration right now. And instead, we're getting now 2 pages into that's not true. That's what we're dealing with right now. That's what we're dealing with right now. Before he passed away, not with her and the Grant's neighbor would bring the plaintiff's mother dinner and help around the house before she passed. In fact, contrary to story around the clock devotion, the complaint it reveals the plaintiff was adamant she did not want to be associated with any of this and failed to be involved in the foreclosure action. Indeed, the plaintiff was so absent in her parents' lives, it took substantial time and significant effort for the creditor in the action to locate her and identify her as the parent's next of kin. So, yes, we moved on to that's not true. No. No. So, motion to compel arbitration. And we're sitting here saying, "Nuh-uh, she's full of shit." So the defendant's or plaintiff's complaint is further riddled with fabrications and omissions. Plaintiff and defendant knew the other was also involved in other romantic relationships. Plaintiff was living in Park Tower, a luxury multi-million-dollar building in Stamford, Connecticut, with her longtime fiance, attorney Brian Goncalves. Since August 2022, he had served as the one of these senior vice presidents of Univision, and he had previously held positions at MasterCard and Hewlett Packard. So she lived in the same building as the defendant, just 4 floors below, when they began their affair in 2019. She would often visit the defendant at his condo at all hours to pursue their affair and then return back to her condominium at Goncalves at night. It's nonsensical that disturbing alleged facts, including violence, of course, sex, and forcing to be defecated on, were taking place before she went downstairs. The defendant was never contacted by Goncalves or Calves, who was on the board of the luxury building. Anyone at the building, the police, any friends of plaintiff, or any lawyer or advocate for plaintiff at any time about the fictitious, extensive, years-long abuse. Now, that's going to be interesting because it's one thing to say, "Oh, fuck this bitch, she's lying." But this, I kind of get the feeling that's true, chat. I kind of get the feeling that might be true. Did I see her little acting gig? No. Goncalves. Okay, there we go. Didn't they fuck the shit out of her? Well, no. Vince. Well, Vince fucked the shit out of himself. He just kept on fucking. He's like, "Oh, I knocked the poop loose. Get over here, Janelle." True. That be true. Yes. Janelle, my toilet's clogged. Can I use your hair? No. So let's keep going with this. This is, like I said, Chef, this is pretty good. Pretty good stuff. Why is this just freeze up on me? Oh no. Oh no, I'm gonna lose it. Oh no, it did not go down. Okay. After 3 years and having decided to return to their partners, plaintiff and defendant agreed that their affair and separate from each other, which is nice. So plaintiff leaving the company where they work, WWE Incorporated. Plaintiff and defendant entered into a binding contract to memorialize that agreement entitled Confidential Settlement Agreement. Generally said covenant not to sue, is Exhibit 1. Plaintiff initially wanted to include in the term in the contract mandating defendant could not move out of their shared building. That's weird. Defendant wanted to include that in the term and did move out. That's a weird term. Why would she want that? I'm trying to think. Why would she want that? Plaintiff's contention that the contract between the defendant and WWE on one hand and the plaintiff on the other is not enforceable is utterly meritless, but that is an issue for the arbitrator. In fact, the parties wish to preserve the confidential and private nature of any disputes under the agreement. They specifically provide in the agreement disputes will be resolved through arbitration. Plaintiff was represented by a lawyer who negotiated the agreement before she executed it. That's a big thing. She had a lawyer and he negotiated on her behalf. So she can't say, she can't claim, Oz didn't know. He had an attorney. When the defendant learned the plaintiff's side of promises had violated the agreement by wrongfully disclosing both the existence of the agreement and the relationship, he exercised his right to withhold payment otherwise owed under the agreement. In response, plaintiff sought to harm him. She intentionally violated the enforceable contract with her salacious, false, and defamatory filing. However, the FAA in binding U.S. Supreme Court precedent, and there is Supreme Court precedent on arbitration. There's actually surprisingly a lot, more than you'd think. And plaintiff's own agreement required that a plaintiff wishes to proceed with her claims, she must do so in arbitration, not in this court, and that this action stayed pending arbitration. As this is a pre-answer motion, defendants not specifically address the substantive merits of the counts asserted against him. But you kind of just did. You kind of just said she's full of shit. For the avoidance of doubt, however, defendant vehemently and categorically denies allegations of wrongdoing in the complaint, including plaintiff's outrageous claims the defendant coerced plaintiff into unwanted sexual acts, battered, trafficked her, and then defecated on her. Can't forget about the poop. Big old chunk of poopy. Those are false statements intended for publicity. When the complaint's allegations are adjudicated in the proper forum, arbitration, witnesses are called to testify under oath, and that's true. Witnesses are called to testify under oath. It's all documented. And all communications between the parties, includes offered by the plaintiff, which she intentionally did not share in her complaint, and you do get discovery in arbitration, are produced, the allegations will be disproven, and she'll be exposed for the liar she is. Meanwhile, here's why our thing should be granted. Plaintiff is 43 years old. She was born in 1980. Her parents, Jane Grant, Anthony Grant, and grew up in Mount Kisco, New York. From 1999 to 2002, she lived in LA and began a career in acting. In 2001, plaintiff bid in an auction to be featured in the film Who Wants to Be a Movie Star? I've never fucking heard of this. As one of the actors with 5 lines and under. I've never fucking heard of this movie. Subsequently, 2006, the plaintiff is featured in the film The Theory of Everything as a hospital receptionist. Okay. She spent the majority of her adult life as an equestrian rider and owning horses. Oh, yes, the horses. It's like Vosh. Vosh, like, well, you have my attention. And Vosh going, Actually, this is Vosh. He's like, I'll play with my ear, play my keloid on my ear. Yay, we should all have co-ops chat. According to a lawsuit filed by plaintiff against several defendants for an alleged injury sustained by plaintiff's horse, the plaintiff had moved back to the East Coast by 2002 was actively engaged in the equestrian community around the same time. Okay, so she already had another case in the Southern District of New York. When they met, plaintiff told defendant she had received a law degree but never took the bar exam. Based on our representations, the defendant assisted Senate meets WWE's Human Resources to apply for a position in the legal department as legal administrator and coordinator. I don't recall in the thing it said she had a law degree. I don't recall that. Yes, they pooped on her too. Yes. Yes. Yes, bear bucking. Yes. Do you think she has videos on heavy? Maybe. That would be great. My sound is garbling. Is it garbling still? Oh. Oh gosh, scaring me. I'm gonna go to I'm gonna come. More. And Reformed Convict's been a member 6 months. Thank you very much, by the way. Saying, you ever given Cleveland Steamers since you live there? No. Nor have I thought about giving a Cleveland Steamer while on a Cleveland Steamer. That'd be real meta. So they talk about why do we have the arbitration agreement? How is it binding? Well, there was negotiation and entry into the agreement. The negotiation in monetary terms. So the consensual relationship she was engaged to her boyfriend, resided with him in a luxury apartment, lasted a little less than 3 years and ended in January 2022. On December 24th, 2021, shortly before the parties' relationship ended, as reported in the New York Post, Grant penned a lengthy email to McMahon, which she called him my best friend, my love, and everything. Okay. The negotiated agreement where she would receive monetary compensation and a consideration of various mutual promises and covenants. Okay, so plaintiff negotiated on her own behalf in the first instance, which is kind of a red flag. The defendant initially intended the monetary consideration to plaintiff under the agreement to be in the range of $1 million to $1.5 million. Plaintiff negotiated the monetary provision in the agreement by telling the defendant his initial offer of $1 million was not enough to compensate for the lost earning potential and the fact she would be unable to continue the promised career trajectory of vice president. Yes, and see, that's a thing. That's a common sexual trafficking victim problem. You weren't going to promote me. And she thought the proper amount was $3 million. She also wanted the $3 million to be paid as a lump sum. And Vince is like, no, we can't do that. So the agreement was that the first $1 million would be paid out, and then the rest would be paid in 4 installments of $500,000 each time. So, and if you guys don't remember, we actually have the. Hold on here. Where is? I think I got some. Oh, hold on. It's in my Dropbox. So, we actually have the WWE. We have the WWE's actual agreement that they had with her. We went over that the last time, but I think we should take a look at it again. Why is there? I only got one window open, and Google is bogging it down. Annoying as hell. So, and this is an example of one of the provisions. The $1 million immediately, and provided all the obligations that Grant fulfills, the sums will be deposited over the next couple of years. So each year afterwards, on February 1st, you get $500,000. 2023, 24, 25, and 26, she get $500,000. And she had to keep confidence of all this stuff. So the plaintiff admits in her complaint the parties each retained counsel who were involved in the drafting, editing, and negotiation of the agreement, which at that point goes against Janelle. If it was just Vince on his own and her on her own, she'd been to law school. Vince hasn't, but Vince is a very savvy businessman. Court might say you're kind of like on the hook for what you do, good or bad. Now, Vince is represented by attorneys, and she's not. That's considered uneven bargaining, and they won't necessarily hold conditions against her within reason. So there is importance that both parties are represented. And we have the WWE. So the WWE's you guys don't remember, this is it here, the WWE's confidential settlement agreement. We covered this before, and it's all highlighted up. So we went through all of this, and it's not super long, and it disclosed everything they had to do. And it's signed by Janelle on 118 or 128, 2022. So we do know it exists. Indeed, the course of negotiating the agreement, plaintiff's counsel, Jonathan M. Shapiro, of Eaton Law Partners, in an effort to reinforce the strength of the arbitration clause, proposed the following language be inserted. In the event of a claim of breach under this agreement by any party that results in arbitration or any legal proceeding, the prevailing parties determined by the tribunal or court shall recover from the non-party all resulting costs and attorney's fees. So basically, if it turns out you win or they determine you were most correct, you can go back to the other side and pay up, sucker. Although the finalized agreement did not incorporate that proposed language verbatim, the arbitration provision states the prevailing party in the arbitration shall be entitled to recover from the non-prevailing party all of its attorney's fees and costs. Okay. So the release of claims. In the agreement signed by all parties, the plaintiffs mutually agreed to release any claims they have against one another. Specifically, plaintiff agreed to release the defendant of all claims she has ever had as a result of, or in connection with her employment relationship with WWE, the termination of that employment relationship, and or any and all matters involving her relationship with Vince McMahon or other WWE personnel, including Cock Lesnar. By signing this agreement, she acknowledges she will have waived any right she may have had to pursue or bring a lawsuit or make any legal claims against McMahon, the WWE, or its officers, employees, or representatives. Still further, the agreement stated Grant agrees she will not cause and has not caused to be filed any legal action, administrative procedure, arbitration, or changes in nature of whatsoever relating to McMahon of the WWE concerning her rights that she's agreed not to. And that she will be forever forbeared from pursuing any legal proceedings, except as necessary to enforce the agreement, which she's making the argument Vince quit paying. Well, she has the right to force that. And then finally, Grant agrees she shall not institute or be a party to any lawsuits, either individually or as a class representative or a member against McMahon and the WWE. She knowingly and intentionally waives any right to any additional recovery that might be sought on her behalf by any person or agency thereof. It's difficult to conceive of a more clear and unequivocal release and covenant not to sue. Similarly, Vince McMahon and WWE agreed to release and forever discharge Janelle from any and all disputes, claims of actions, demands, suits, attorney's fees, expenses, debts, contracts, and agreements. So they basically did the same thing. They cut her loose. Now I understand I'm just not sure. What was I going to say here? I forget. Right, top of my head. Just DM'd her 4 lines of acting on X. Oh, Cat, thank you. We'll take a look at these in a second. I hope they're good. Or is it bad? Oh, okay. Thank you, Kat. I appreciate it. All right. If you guys want to see Janelle, here we go. Here's Janelle.
Listen, I know what room he's in. Can't I just go back?
Nobody's allowed in without an escort, sir.
You gotta be kidding me.
Are you here to see Mr. Holland?
Yes, how is he?
Why don't you come back with me?
That's it. Oh, she's got another line. She's got more lines. Here we
Please,
go.
WELCH. Welch.
Hello.
Okay, I'll hold.
Hello? Can somebody around here help me?
Okay, how can I help you?
Go get your supervisor, bring him here, and have him explain this to me.
Down.
Hurry up! Now! Go!
Going. I have more minutes.
That was it. Okay. Well, phenomenal work. Phenomenal work. She is a tour de force, chat. Tour de force. Yeah, she was in a Christian movie. So much talent. So much talent. She definitely looks like someone that could take a rotisserie. Yeah. I would poop on her face. I don't know if I would, but Dave Portnoy's arch rival at Business Insider got fired today. Ooh, that sounds like they got scared of that lawsuit. Content Lasagna says WWE personnel. Brock is an independent contractor and not WWE personnel. Yes, you are correct. Technically correct. I still want her to fuck Brock, though. I want him in the Big Show. To see if they can make their tips touch inside of her. She was pooed on while filming these. Was she getting pooped on while filming these Christian movies? No, this is before that. That would be even better. That would be even better. Yes, where's the Big Show? Tell him to get here. Tell him to get here. Yes, Big Show. I've got a skinny white girl that you can rail. I want you and Brock to break her in half. So they waived everything on their side of it. The arbitration provision. The agreement also contains a broad arbitration clause, which we're going to take a look at real quick here. There's two PDFs. The WWE's NDA. Is this one all marked up too? Because I don't want this one all marked up. So let's see if we can go back through this for the ARB. Oh. Yes, so here we go. And this is something we talked about when we watched this or looked at it previously. Okay, here we go, chat. This is going to be perfect. Okay. So here we go. So we've got arbitration. Yes. Well, that's it there. No widows and orphans. Fix that shit. That is so damn annoying. So in any event, if you can't agree to anything, all the exclusive legal method to resolve any and all disputes is to commence binding arbitration of the Federal Arbitration Act pursuant to the procedures of the American Arbitration Association, which you could do arbitration. Like, generally it's attorneys that do arbitration. There are like high level arbitrators. Sometimes they're former judges. A lot of like local courthouses that have mediation use former judges and other skilled attorneys. Like if you're doing arbitration though for a living, you can make some good fucking money. Especially when you hear like in the MLB, like when baseball players have their contracts go to arbitration, those guys are eating good. And to do so by sealed proceedings which preserve the confidential and private nature of the agreement. So no matter what, it's all private. Nobody gets to know. Okay. So yes, arbitration was mentioned in their agreement. And Janelle is like, no, I don't want it. And Vince is like, yes, you must take it. One wrestler tweeted she wanted to unionize that she was fired 10 minutes later. No joke. That doesn't surprise me. That doesn't surprise me. Oh crap! We lost it. Chat. Hold on. All right, we're moving on here. Okay. So any dispute arising in its construction, interpretation, application, performance, or breach contains an arbitration clause. If that attempt is unsuccessful, the arbitration clause mandates a sole and exclusive legal method to resolve any and all disputes or controversies is to commence binding arbitration of the Federal Arbitration Act. And this is what we just talked about here. So the exclusive legal method here is to resolve and commence under the Federal Arbitration Act, pursuant to the procedures of the American Arbitration Association, and seal the proceedings to preserve and make it confidential still. And at that point, everybody's still agreeing to confidence, even the arbitrators. So the agreement has severability portions. And I mentioned these before. Severability portions are where it survives. And here's how severability works. In the event any provision of this agreement is held to be void or unenforceable by an arbitration panel or a court reviewing the decisions, the remaining provisions shall nevertheless be binding, provided, however, if any of the confidentiality obligations of this agreement are ever contended to be unenforceable by grant or are found to be unenforceable by any tribunal, she agrees to return all the money she paid. So, and since Grant is claiming that the confidentiality provision is unenforceable, Vince McMahon's reserving his right to demand the return of the monetary compensation of $1 million, which he's already paid her. So it's like you make that claim, there's a lot there. And then the agreement was signed by the plaintiff. She signed it. She represents she is able to read the language, understand the meaning and effect of the agreement. She has read and understands the agreement and the effect of it. Her attorney explained it to her, and she did this unequivocally acknowledged among the rights she is knowingly and voluntarily waiving by executing the agreement is the right to pursue any claims against Vince McMahon of the WWE. So she's doing this in violation of the agreement because she got paid the $1 million. However, because she failed to comply with her confidentiality obligations, the defendant did not pay her first of the four $500,000 installments. Then, rather than sue defendant for breach of contract in arbitration, which is how you do it, you make the allegations of breach of contract in the arbitration setting. In complete disregard of the clear terms, she initiated the instant action in January. God, it's been so long already. It's been a couple of months. Alleging various actions against the defendant and John Laurinaitis. The allegations are once again replete with falsehoods and misstatements and irresponsible mischaracterizations. All right, well. Now we get to the actual case law and the legal arguments about arbitration. This is going to be a little dry, but it's actually interesting, guys. Written agreements that arbitrate controversies out of an existing contract shall be valid, irrevocable, and enforceable save upon such grounds as exist at law or in equity for the revocation of any contract. So how do you revoke a contract? Well, there's a couple of different ways. Duress, undue influence. There's a lack of a manifestation of mutual assent, meaning you didn't understand what you're doing there. There's a lack of consideration. There's a couple of different ways you can kill a contract. And if you can kill that contract, well, that arbitration clause might not survive if the contract dies. So it's just acknowledging that it's not bulletproof, but it's pretty robust. And there's a liberal federal policy favoring arbitration agreements. Why? Because the court doesn't want to fucking deal with it and they'd rather go piss off somewhere else. There's a strong federal policy favoring arbitration as an alternative means of dispute resolution. And if you guys ever hear of the term alternative dispute resolution, so known as ADR, that's what arbitration is. Arbitration, mediation, all kinds of things the court wants you to do so that way it doesn't have to work with you. Because the court doesn't want to deal with you. You are in the way of other stuff. Nancy Korensk, or Korensek. Nancy Korensek for $2 says, excellent Vince voice. Well, thank you. Thank you. J-Rex says they get 3 arbitrators. It will be a panel. Okay. Okay, yeah. I didn't know that's how that worked. But yes, sometimes you get a panel of arbitrators. Sometimes you get a single. But thank you for that, J-Rock. They coming at your boy Ric Flair saying he was drunk and high when he was standing on business. Oh. Tarika Demesto says, no wonder you're tired. After getting pummeled by DSP, at least he didn't take a shit on you, literally. You know what? And it is true. I mean, King Philip, made his edicts, and I didn't want to accept them. But yes, the king has survived a long and healthy reign of House Brunel, as PPP did say. Yes. And they may not pay their debts, but they persevere, and something to think about. Something to think about. Now, there are times where you can, the question of whether the dispute is to be arbitrated, the question of arbitrability, is an issue for judicial determination unless the parties clearly and unmistakably provide otherwise. In determining whether to compel arbitration, a court must determine whether the parties entered into an arbitration agreement. If so, the scope of that agreement, does the federal statutory claims asserted whether Congress intended those to be non-arbitrable. And sometimes that is an issue. Congress said, like, nope, you can't arbitrate these. And then some, but not all claims are subject to arbitration, whether the state of the balance of the proceedings pending the arbitration. So some of the claims can be tried and through an arbitrator. You try those ones, and then everything else that has to go through a regular court suit, you hold off until the arbitration's done. So the party moving to compel bears the initial burden of showing arbitration exists. The party resisting bears the burden of proving the claims at issue are unsuitable for arbitration. Any doubts concerning the scope of arbitrable issues should be resolved in favor of arbitration. In order to arbitrate, the particular grievance should not be denied unless it may be said with positive assurance that the arbitration clause is not susceptible of an interpretation that covers the asserted dispute. And once again, if you're not sure, resolve it in favor of coverage. So in motions to compel, courts apply a standard similar to that of motion for summary judgment. Yep. So, yes, so their argument is that this is a valid and enforceable agreement to arbitrate. They're saying it's good, man. They're saying this is primo stuff. This is good stuff. J-Rock says you have to specify a single in the agreement. Okay. Otherwise, the AA jams. The jams is a separate arbitration association. Defaults to 3 arbitrators, which is super expensive. $1,500 to $3,000 an hour for fees per hour. Yeah, it's arbitrators eat good, and they're good arbitrators are good in high demand. And those are Atlanta prices. Yep. Yeah, one arbitrator costs. Yeah, that's the thing. I've sat through an arbitration, like I've been in the back, just watching one go down, and the arbitrator made more than the attorneys doing the case. Arbitrators are good, and these guys, the parties agree. Like sometimes the parties agree, like we'll pick it, like we can agree to pick an arbitrator, and they wanted to pick one who has some experience in an area. And yeah, that guy made all kinds of fucking money. Tilly says, "How do I become an arbitrator making that coin?" It's not easy, man. It's not easy. So, the threshold question of whether the parties intended to agree to arbitrate is determined by your state contract law principles. So, in this case, it was all done in Connecticut. Here, the agreement states it was made in and shall be governed and construed under the laws of the state of Connecticut. Under Connecticut law, the arbitration provision contained is valid, enforceable, and irrevocable. So they do point out, though, if this motion does get denied, and it should not be, we reserve the right to dismiss under Rule 12 of the Federal Rules of Civil Procedure, based on release of claims of Section 2 of the agreement. So they're just arguing, like, look, we'll have a chance to take, like, if you deny this, we'll move on formally. So, and this is basic contract law. The fact you signed a written agreement is usually conclusive of contract formation. The presence of a written agreement is generally strong evidence of contractual relationship. When an agreement is reduced to writing and signed by all parties, the agreement itself is substantial evidence of a meeting of the minds has occurred. And that's what I talk about, that manifestation of mutual assent. The meeting of the minds. Does everybody agree to the terms? Is everybody in agreement? They point out when a person of mature years who could read and write signs or accepts a formal written contract affecting his interests, it is his duty to read it, and notice of its contents will be imputed to him if he neglectfully fails to do so. So, holding the circumstances, and this is a case out of Connecticut here, surrounding the making of a contract, purposes which the parties sought to accomplish in their motives, they cannot prove an intent contrary to the plain meaning of the language used in the contract. So you can't, the language is what it is unless you're, spelling it out. And not only did the parties sign the agreement, they were represented by counsel when the agreement was formed. Plaintiff also said that she entered the agreement knowingly and voluntarily. She understood the agreement, its effect, and her lawyer explained the terms of the agreement to her. Indeed, she negotiated the agreement to her advantage. Yep. So they're saying she's bound by the arbitration agreement. Okay. And it's valid and enforceable between the parties because counsel for both parties were involved in the review and execution of the agreement. Like I said, guys, having a lawyer involved on both sides, there's a lot that gets imputed to you that you're sophisticated, you understood what happened, that you're not just some yahoo. You are an educated person. You did this. You knew what you were getting involved with. Do you have to be an attorney to represent somebody in arbitration? I don't. I think yes. I don't see why you would. I don't see how that's the rules of the arbitration associations otherwise. Yeah. Practice law for a long time or be an ex-judge. Yep, that's how you become a mediator and arbitrator. J-Rock says they forgot to put in the contract two things. The arbitrarily issues to be signed by the arbitrator. Okay. The instant fee awarded against the party for filing in court for the party that has to enforce. Yeah. Damn, you civil people know all your stuff. You civil people, you civil attorneys, your fucking voodoo, your arbitration agreements. I arbitrate with a Glock. That's what I arbitrate with. That's how my clients arbitrate. Vince manifested something. Yeah, a turd. Oh. Never seen a non-attorney in arbitration. I don't think you could. Kimbo's saying, so the lead attorney is a mediator because he's a good attorney or a good lawyer. Yeah, typically mediators, I think he does it like in family court, but you're still generally considered to be a fairly competent attorney. You're generally well respected. You're considered even keeled, that you don't try to fight all the time. You're generally held in well regard. So that is not a yeah, that's not a uncommon thing. And what they used to call like family court mediators, they were called like referees in a lot of places back in the day. So, but that's not what we're dealing with right now. So, but yes, you can do a lot with an arbitrator or a mediator. Yep, you rep yourself in arbitration, companies too, I believe. I think you get the right to have an attorney in arbitration, though. Because I represent parties in mediation. Oh yeah, you can't represent yourself in arbitration. Companies too. Yes. Okay, yeah. You left out a critical word there. You can rep yourself, but that's a bad idea. I would never recommend representing yourself, even in an arbitration setting. Kimbo says, I'd hate to be a mediator in family court. It's got to be brutal. Yeah, well, they do help people kind of chill the fuck out. It is very helpful because the attorneys are trying to work it out, and then the mediator's a party that sits down and says, look, you guys are, both you guys are going to hate this agreement, and that's the best kind of agreement. So, J-Rock needs more alcohol. Harvard lawyer Lee is a mediator. Yeah. Yep. It's not uncommon. I mean, it's out there, but yeah, to be an arbitrator though. Yes. There are no court-appointed attorneys in arbitration. Yep. No right to counsel. You have the right to bring your own counsel, but you're not entitled to have counsel provided. That's a very good point as well, J-Rock. I want more dog. Well, the dog, I think, is sleeping. So, the challenge of the enforceability of the agreement as a whole should be decided by the arbitrator and not this court. And that's true. The arbitrator's got to look at it. That's why you have a judge or a well-seasoned attorney get involved. The plaintiff's challenge the enforceability agreement as a whole rather than the arbitration provision has no bearing because the issue should be decided by an arbitrator. Yep. And this is where, guys, we're going to talk about the Supreme Court getting involved in arbitration agreements. The United States Supreme Court addressed this very issue in Renner Center, West v. Jackson. There it said there are two types of validity challenges under Section 2. One challenges the validity of the agreement to arbitrate, and the other challenges the contract as a whole, either on a ground that directly affects the entire agreement, whether there was fraudulent inducement, or on the ground that the illegality of one of the contract's provisions renders the whole contract invalid. So that's, I forgot to include fraud as another one. Fraud, duress, undue influence, lack of consideration, no mutual assent. and they say only the first type of challenge is relevant to a court's determination whether an arbitration agreement is enforceable. As a matter of substantive federal arbitration law, an arbitration provision is severable from the remainder of the contract. Section 2 of the, I think they mean the Federal Arbitration Act, states a written provision to settle arbitration and a controversy is valid, irrevocable, and enforceable without mention of the validity of the contract in which it is contained. So they further go to clarify things, and they say, that where the alleged fraud that induced the whole contract equally induced the agreement to arbitrate, which is part of the contract, we nonetheless require the basis of challenge to be directed specifically to the agreement to arbitrate before the court will intervene. So they're saying, in other words, if a party challenges specifically the enforceability of a particular agreement, the district court considers a challenge. But if the party challenges the enforceability of the agreement as a whole, the challenge is for the arbitrator. And that's the thing. If you're challenging one little spot, a court can take a look at it. If you're challenging everything, well, an arbitrator has to decide. Yeah, J-Rock's saying it was a typo. You can rep yourself. Yeah, I understand you're saying you can rep yourself. I don't know why you would. That's not a good idea. Yes, I heard you. I heard you. You can rep yourself. Yes, we mentioned that. You can do it. I don't know why you would, but you could do it. The FFA. Now you're just fucking trolling me. J-Rock for $5. Thank you. It was a typo. You can represent yourself in arbitration. And I say, I understand you. J-Rock. Mon fils. Mon chéri. I can hear you. What are we talking about? I think most people would be ready to quit in a situation where they have to mediate a custody case where the kid has been diddled, which I think lead attorneys had to do. Well, yeah, that's the shitty part about it. Yes, you don't. More. Well, we got more coming, guys. All right, so we're gonna keep going here. What time is it right now? 11:30. Damn, we were going. All right. So, following the Renner Center decision, courts have routinely declined to consider challenges that were not specifically directed to the arbitration clause. Unless the challenge is to the arbitration clause itself, the issue of the contract's validity is considered by the arbitrator in the first instance. Yep. Here, the complaint asserts that the Speak Out Act bars the non-disclosure clause and the non-disparagement clause in the contract, and because the clauses are the core terms of the agreement, the entire agreement is judicially unenforceable. They then say it's void based on grounds of attacking the agreement. So she's argued that it's an impermissibly broad confidentiality provision. She entered the contract under duress and undue influence. Is a contract of adhesion, and adhesion contracts are not found to be good. We don't like those in America. It's substantively unconscionable. That's another example. So, for example, guys, if me and you signed an agreement, a contract, and it was like, you pay me $100 every day for the rest of your life, and people are gonna say it's unconscionable. It's gonna make you go poor. They say the agreement is void against public policy. That's another issue. Public policy may not allow us to do the contract because in public policy we don't want that. So, like, such as agreements to commit crimes, or if you and me get into a contract that I'm supposed to ship you cocaine and I don't, well, you can't sue me in court for not following through on the cocaine delivery. We aren't going to allow you to file a lawsuit over illegal behavior like that. None of these challenges make any reference to the arbitration clause. nor is there any factual basis challenge to the clause itself because there is none. They say quite contrary drafts of the agreement indicated the parties negotiated the arbitration clause at arm's length with the help of counsel. And at arm's length just means that, it was an arm's length transaction. And so she's challenging the agreement as a whole, or on the grounds that the illegality renders the whole thing invalid. It's for the arbitrator. Jack says, do you understand what I'm saying? Do you understand the words that are coming out of my mouth? Quote Major Payne. Yes. Hold on, J-Rock. He's saying, can I dig it? Can you dig it? Yes. Can you dig it? You got Cyrus, head of the riffs. It's a great movie. And now here, this is a big footnote. Defendant will establish an arbitration that each agreement the plaintiff raises to invalidate falls under the applicable law. As a brief example, she entered under this duress or coercion. Courts in Connecticut have repeatedly held the party who executed the contract under duress accept the benefits flowing from it or remain silent or acquiesces in the contract for any considerable length of time after the opportunities afforded to annul or avoid it. That party, because of the ratification, cannot assert duress or undue influence as a matter of law. And that's fair. And they're just saying, look, if you sit on it you sit on your rights for too long, you waive them, especially if you're receiving all the benefits. And she did. She received 1 million benefits. There's a point out that even 2 months is too long to sit around and not say anything. The big thing here is it's almost 2 years later where she does it. Yeah, that's a very poignant point there. So her claims fall within the scope of the arbitration agreement. And yes, you read these as broadly as possible. So any doubts concerning the scope should be resolved in favor of arbitration. Okay. Yeah, here all claims alleged in the complaint are within the scope of the clause. So that's where we got to go. So the courts repeatedly enforced arbitration clauses with similarly broad language. So in Connecticut in 1996, for example, the Supreme Court held that an arbitration clause mandating any disputes arising under the employment between shall be submitted to the American Arbitration Association was all-embracing, all-encompassing, and broad. Okay. So they talk about in this case, Fink here, Fink v. Golenbach, or Golenbach, was found to be broad and unrestricted such that it encompasses tort claims as well as statutory claims. So the inclusion of such broad language generally includes all claims, including tort claims. And they point out that the broad arbitration clause in the agreement encompasses encompasses her contract claims, her statutory claims, count 3 and 4, and her tort claims, 5 and 6. Oh. Further, in Connecticut law, like federal law, the arbitration. Oh God, that's why I'm getting chilled. There we go. That'll probably help. The arbitration must be compelled unless it may be said with positive assurance the arbitration clause is not susceptible of an interpretation that covers the dispute. So this is challenging the enforceability. She's initiated a dispute on the construction, interpretation, and application, and the performance of breach. I mean, so this is exactly what it's meant for. Okay, Booch, I'll get to that in a minute. Okay, so we're gonna keep going here, chat. We're gonna round this out. So while courts to strictly enforce arbitration clauses that mandate and may be overridden by congressional intent. And this is another case. This is a Supreme Court case from 1987. You could tell because the reporter is U.S. Such an intent may be deduced from the legislative's text or the statute's text history, or from an inherent conflict between arbitration and the statute's underlying purposes. So, does a law prohibit that? Has Congress said, no, we don't want arbitration in these situations? So, she uses the Speak Out Act, which renders pre dispute non disclosure clauses or non disparagement clauses unenforceable in disputes involving sexual assault and sexual harassment. And because of that, with the Speak Out Act, the agreement terms make itself judicially unenforceable. Um, that said, though, the Speak Out Act does not prohibit the arbitration of any claims asserted in its case. So, if you're going to cite the people being harassed and you drive up to them, you know, no, straight that we're going to leave that there. Basically, with the Speak Out Act, you can't claim, oh, well, I'm a victim, so therefore I get to run around on this. No, the act doesn't prohibit the arbitration of claims. So you can say, I was trafficked, I'm a victim. Okay, but the law doesn't provide for that. Generally the law may provide something that snips an arbitration claim, but it's not in here. And based on the text of the statute, you have to assume Congress intended to limit the application of the act to only non-disclosure clauses and non-disparagement clauses in the pre-dispute agreements. And they say no non-disclosure clause or non-disparagement clause agreed to before a dispute arises shall be judicially enforceable. Blah 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 blah. Nothing in the text of the statute, legislative history, or the underlying purpose of the act suggests a congressional intent to render a related arbitration clause unenforceable. The Speak Out Act is thus not a reason to find the plaintiff's claim should not be compelled to arbitration. Now, she does get on to and we talked about this before, the Trafficking Victims Protection Act. Same thing in the Diddy case, which imposes no prohibition on arbitration. The TVPA is silent on the issue of arbitration, and no conflicts exist between the arbitration and the TVPA's underlying purpose, which is to combat severe forms of worker exploitation that do not amount to actual involuntary servitude. So that's the limit. And they point out courts have routinely compelled arbitration of TVPA claims. They did in the Eastern District of New York, the Southern District of California. So, the court should stay the pending action pending the arbitration. So the courts have the inherent power to grant a discretionary stay of proceedings. I mean, that's the issue. They can't do it forever, but they can withdraw everything until this issue is resolved. And then they can get back to putting people down a tunnel and sending them off to Siberia. So, and to determine whether a stay is justified, a court must consider, are there common issues between the arbitration and litigation? Yeah, pretty much. Whether those issues are likely resolved in arbitration? Nope. Whether the failure to grant a stay will prejudice the defendant? Yes, it will. And then 5, actually, yeah, so 4 is there, and that's, yeah. Why? So Janelle's fucked. Yeah, I think so. I think so. I think at this point she's really in trouble. Like I said, arbitration clauses are very fucking strong, guys. So when it talk about trying to handle the case here, the court, they're like, just like, look, judge, just kind of push this off for a little bit. For all the reasons they want to compel arbitration and stay the litigation. So that is that. Now, Janelle immediately. Well, there's one other thing from Vince. Vince did a declaration. So he's declaring on the penalty perjury pursuant to the code, or applicable code. So let's do this, Vince. So I had a 3-year relationship with Janelle. When it ended, she signed all the stuff here. A true and correct copy of the agreement is annexed as Exhibit 1. Before we involve the respective attorneys, she negotiated the monetary compensation that would pay her under the agreement from $1 million to $3 million. So they talk about on or about January 20th, my attorney sent a draft of the agreement to her attorney. On or about a couple days later, that attorney sent a revised version of the draft. Sent it to my attorney with this revision. The plaintiff added proposed changes to the draft agreement. Then they talk about all the stuff here that got included, and it's yes. They added the following language to the arbitration provision. Any party that results in arbitration or in legal proceeding, the prevailing party, the guy who wins. So that is the good news there. And Vince McMahon signed it. He's like, I'm Vince McMahon. And this is just a copy of the WWE's agreement. So these are all the parties. This is what we looked at before. Signed by Janelle, signed by Vince, and then signed by Vincent McMahon as the head of the WWE. Now, Janelle Grant is saying, wait now, hold up. Janelle's saying, no. No. Wipe up that steamer. J-Rax says you choose the cases that hold on here. J-Rax says I've never lost an arbitration motion in 21 years. Yeah, I mean, that's the thing, guys. That's how, I try to tell you guys stuff's not bulletproof, or motions can be defeated, or things are not bulletproof. Arbitration agreements are pretty much the only thing that's guaranteed. Anytime it's arbitration agreement, boom, follow the agreement. Yeah, you're never gonna lose them, pretty much. So it's gonna be tough for Janelle. She's kind of screwed. Patty says, why are they bulletproof? Because you're giving courts an out. Remember what I said? Courts love these because now we don't have to do anything. Well, you're telling a judge, wait, I don't have to do something. They love them. And it fosters the lack of the use of courts because the courts are already overburdened. Because of that, courts want to get you involved. Vince is still finding ways to fuck Janelle. Yes. Yeah. If she loses, how much it is damaging? I don't know. She's going to be on the hook for a lot. And Vince will be able to say, "Give me that $1 million back, girl." And yes, J Rock, you're representing corporate clients. Yeah, that also helps. That helps a lot. J Rock works for the man. Vince is still a savvy cutthroat businessman. That's the only way you get to be as big as he is, by being cutthroat. So they are seeking to strike. And we need to start here. Actually, this is the proper page to start on. So this was filed about 2 weeks ago now. So this is funny. They get all butthurt, chat. They get all poopy in the loopies. So instead of using his motion in the appropriate manner to raise legal arguments concerning whether the dispute must be submitted to arbitration, Vince instead uses the preliminary statement as a platform to launch vicious falsehoods, attacking Janelle's moral character in a transparent attempt to harass and intimidate her into submission. So they say that McMahon's easily refuted lies have no place in this case. Where the fuck does she live? Because that's not reasonable. I'm a little concerned there. So, for the avoidance of doubt, the plaintiff's instant motion to strike is not a response to the merits to the argument set forth in the motion. I mean, but I don't know why they added that. Oh, and J-Rock said, yes, I wrote these, so. Yes, and I work for Capitalist Pigs. I love them. Oh. So we're gonna get back to. We'll get back to this here. When Trump spear tackled Vince McMahon, yes, it was. Yes, it was. So this court has inherent power to strike a party's filings. Yep, but Janelle is actually gonna have to bring that forth in a document. Why is it doing that? So this is her response. All right. So this is her memorandum in law in support of her motion to strike. So this one's short, guys. It's only 8 pages. Error, bookmark not defined. I know that's one too well. I have that happen all the time when I try to do drafting online. That happens to me all the time. Oh, this court has the power to remedy litigation abuses. Okay. The offending statements are clearly the type of material the court should strike. Okay, so let's see. So this is her little blah, blah, blah part. So even for Vince McMahon, the basis, irrelevant, and false statements in the motion were designed to solely harass and intimidate his longtime victim. These are a new low. For instance, the unsupported notions that Janet was absent in her dying parents' lives and engaged a wealthy attorney when she met Vince are not only falsehoods, as he's done countless times, but kind of do, because, yeah, I'm sure if he would have said, like, oh, so his lies are easily disproven. In truth, while Janelle's father was, so here's the thing. In truth, while her father was in in-home hospice, care during his final days. Janelle continued to provide him with round-the-clock care. At the same time, Janelle had also cared for her blind, wheelchair-bound mother until her death. I'm still calling bullshit on that one. Moreover, Janelle was not dating, let alone engaged to her ex-fiance in 2019. So, oh, I mean, there's gonna be. Well, there's fun with the PDF here, but I'm just thinking. I'm just thinking here. Oh wait, I boomered over on. I'm sorry, guys. Sorry. So yeah, she's saying it's irrelevant. All this here. She's saying that her dad was in in-home hospice and her mom was blind and in a wheelchair. I mean, here's the thing. I mean, these are like super easy fucking claims, one way or another. Either these happened or they didn't. And I'm just like thinking to myself, why would the WWE lie? But it's also just like, it's also like, Janelle lying. I just that these are 100 fucking percent like verifiable. This just that's the thing here. So, but anyways, we're gonna keep going. Moreover, Janelle was not dating, let alone engaged to her ex-fiance in 2019. Okay. To the contrary, her ex-fiance generously allowed Janelle to stay in his apartment as she rebuilt her life following her parents' passing. Notice that's something we didn't know before. That is brand new. That she actually did. Oh, see, now this is where you get the walk back. It's all bullshit. But that's kind of true. We're going to start walking it back. During this time, Janelle had no other job or financial support aside for the friendship and generosity of her ex. Notice we didn't know any of that. The last time around. The last time around, she was basically like living at her parents' house off their money. Yeah, technically, if you're not lying, does that make it kayfabe? How does that work? I mean, that's the thing. Like, I was like, how are we going to prove or disprove this? They're already walking back so much shit. Well, I did live in the same building as him, and I did have support from my boyfriend at the time. Like, we're just walking it back. Consistent with his past behavior, McMahon twists these truths to fit his own narrative. Okay, well, so did you, Janelle. Yet, even if McMahon's falsities concerning Janelle's private life were true, they are not. The statements had no bearing on the merits of Janelle's claims, let alone motion. Well, you included them. McMahon's statements had no place in the motion, which should be construed solely whether this dispute must be submitted to arbitration. So, it was not necessarily reasonable or responsible to use a public filing to impugn Janelle's moral character. Well, she drew first blood, not Vince. Indeed, the desperate attempt to distract from legal substance highlights its weaknesses and the weaknesses of the overall case. Yeah, he doesn't. This attorney's talking a lot of fucking shit, though. Because I forgot to see who's the. We'll check that in a minute. Who's the attorney's of record? So the court is the inherent party to strike a powers filings. Yep. So, But you talking about Janelle, this is all the, sexcapades and all the brutal sex stuff she had to endure. Um, Getting through all that, Janelle filed a complaint in her action seeking justice for the wrongdoings at his hands. So, a couple weeks ago, Vince McMahon filed this motion seeking to compel arbitration. The motion's preliminary statement spends little time addressing facts of law or relevant arbitrability of this dispute. Yep, that's fine. He just considers Janelle a big whore. It's wild accusations attacking her moral character. Yep. And they state the entire preliminary statement is rife and should be stricken. So, while the statements wrote personal attacks, um, it shamelessly accuses Janelle of fabricating her involvement in her dying parents' care and cheating on her fiance. So, this court has the power to remedy litigation abuses by striking supplements. And yes, the courts have the authority to police and remedy litigation abuses. And you aren't, this court may strike a party's filing for bad faith. And yeah, they knew what was in this filing. They knew this is a bit spicy and they still sent it anyway. Full send. That's on them. Um, so the offending statements are clearly the type the material the court should strike. They are impugning her moral character, are the type of unnecessary and inflammatory statements that the district routinely strikes. Striking statements about a party being immoral, granting inflammatory statements in an opposition brief. And strike just means they're gone. They're not in. There's though they never happened. There's no need or basis in the motion for McMahon's actions that Chanel was adamant she didn't want to be associated with her dying parents. Visited McMahon at all hours while engaged to a millionaire and will be exposed for a liar. Hmm. Oh, because it's, at all hours, while engaged to a millionaire will be exposed for a liar. But is that really inflammatory saying she's just lying? I mean, these are mudslinging, not a legal argument. She's fucking lying. But anyways, in an employment discrimination lawsuit that the plaintiff treated his coworkers poorly, there's this here out of Southern District, New York, that um, use of profanity demands on a staff can cause that. Yeah. So they want to strike it here. And this is simple. They're just like, it's too much of an asshole statement. They strike the preliminary statement of the motion and other portions of the court deems proper and then manage Vince McMahon. So they're not even, here's the thing. And J Rock, I think you're noticing this too. The Stockholm steamer gets carpet cleaner. Yeah. They're not challenging. I mean, yeah, notice there's not a response back about the arbitration right now. That's that's a bit of an issue there for Janelle. So that's there's only so much stuff they're going to be able to do. So, and this chat is where we are. We finished up this here. This is it right here. This is where we stopped. And from here, just notice of appearances. Um, this is a motion to compel, and this is from John Laurinaitis, and he's basically joining in with Vince McMahon, saying, "Yeah, we agree. Motion to compel, motion to force that. It's what we want." And yeah, there really hasn't been anything else, just a bunch of attorneys showing up. Vince has until the 24th to do something. And then there was a stipulation. And they offer a proposed they're talking about, they offer a proposed stipulated agreement here to avoid the court time and avoid getting a decision you might not like. So this is just the initial action here of what they want to do, so that the motions to compel arbitration and memorandum of law and their motions shall be filed by May 14th. Okay, well, they've already done that. The plaintiff's oppositions and motions to compel arbitration shall be filed by June 4th, and the memoranda in support of that by June 18th. So that's where they come up with all this. Now, why does that really mean anything for us? Well, it doesn't really turn out to be much, because there is an order approving stipulation, and then there's a bunch of ad hoc proc VJs. So what do we have here? So the court approves and adopts in the parties' 48 stipulation rescheduling as follows. So, yes, there's another, basically like movie seal, because it's basically going to blow everything up in here. So the plaintiff's opposition or oppositions are due by June 4th, and the defendants have until 3/28. Okay, I'm sorry, June 18th. Because the court must apply summary judgment-like procedures, the parties shall file their memorandum with statements of material fact. So, so that is it for now. That is where everything's been done, and we're all kind of caught up for now. So, do I think what's going to happen here? Yeah, I think J Rock's right. She's fucked. She's fucked. She signed the agreement. It's going to go that way. And yeah, it's yes, she's gonna learn about the gnarled cock of illegally seeking this type of resolution when you had arbitration agreements. Yeah, this is gonna be fun. So Dan says, what mic am I using? I am using a Shure 7MB. SM7B. It's the it's Joe Rogan mic. This is not this right here is not from Shure. This is from Toner. This is like my $40 microphone. I just keep using the boom because why buy a new boom? She'll get a book deal to pay Vince. Like, I don't know. I think she's going to lose this here. I think it's going to crush her. Dan says it sounds great. Well, thank you, Dan. Yeah, I think she's in trouble. I think this arbitration is going to work because it's, yeah. Yep. And then after that, she could challenge it, but she's going to lose. And she'll lose handily. So, vivid video to pay Vince. Yes. So, it all depends on the judge. Yeah. mean, these judges aren't going to want to get overturned, these federal judges, because courts of appeals are going to be like arbitration, boom, done. 7 SM7B is great for mental vocals. Like, yeah, I can't do it. I can't do it. Imagine losing $3 million because you can't shut the fuck up. Yes, that's the sad part. Janelle is such a dumb whore. She can't shut the fuck up, and she ends up owing Trump tons of money. Because would her attorney taking this on contingency, or is she screwed with her own legal fees as well? I mean, yeah, she's pretty much sitting there. I mean, generally, I'm betting it's probably was done on contingency. So she's going to be screwed at the end of the day to pay for it. And I bet eventually the MP5s or the never mind. That's not going to work. She's going to be on the hook for everything. The attorney's not going to. He's like, I was following her lead. Here she made these representations to me. Blah 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 blah, and then point out like, look, we did the procedure right. We did everything. We did all the things that it's going to tend to do. We hope for it to, you know, the decision of the arbitration company is not able to be appealed. No, not the decision itself, but they have to go to arbitration first, and then they can challenge whether or not the arbitration was still valid. As far as J Rock, you can help me out here. I can still sue and say the court can determine that this was an unenforceable contract. But at that point, you're still grasping. You are grasping at straws. Only the confirmation of the award back at court. Okay. I thought I could challenge the enforceability of it. Like, we could even have this afterwards. But okay. Like I said, I don't do arbitration, so that'll yes, he can't well, he's gonna keep getting away with it. So yeah, I'm just yeah, she's on the hook. Is she screwed with her own legal I mean, well, the legal fees aren't gonna be hers because the attorney's gonna be like, well, you lost, sorry. Have a good one. They aren't gonna send her a bill in the mail. I mean, if it turns out generally speaking, that's not how that works. Hmm. So, um, I'm just trying to think like what else can she do right now? And it's like, yeah, yeah. Jarek says a confirmation you can challenge the fairness, bias of the award or arbitrator. Okay. Well, if that's it, then she's really fucked. I mean, like those are never gonna be, the court's not gonna be like, oh, he was biased or whatever, because generally they're not. Arbitrators are very level-headed people, super level-headed, and very chill, very chill. The arbitration is going to be held in Wrestler's Court, and the Undertaker's the judge. Well, I don't know if the Undertaker's the biggest fan of Vince anymore. Can she go to AEW? Yes, she can go to AEW. Or she go to ECW. She can hang out with Sabu. Hang out with Sabu and wrap herself in barbed wire. So, yeah, guys, that's it. I mean, she boned. I think she's kind of toast. I tried to make that as a joke at the beginning, like Vince tried the arbitration and it wasn't effective. It's like it's going to be pretty effective because I don't notice they didn't waste time arguing against it. I arbitration. So I think it's the last we'll hear about it very quickly. So, yeah, tomorrow morning, guys, 9 a.m., we are doing Karen Reed. It's only a half day, so we'll be doing that. I thought it was 2 hours of Vince yelling the docs, and I can't do that to my voice tonight, guys. Oh, hold on. All right. So, Karen Reed tomorrow morning, 9 a.m. We're going to do the half day. Dubai pays well for arbitration. Yep. Very good. Vince, me yelling at Vince through the camera for 2 hours, that'll wear my... I gotta keep this thing under wraps. Bush, this New York senator getting karma. No, we can talk about that tomorrow. So that'll be funny. Because we've got, and guys, remember we had the Thursday night show. We got a lot to talk about. Okay. So let's see here. There are German shies of videos in the future. Yes, I don't know. Alabama and South Tennessee got rocked. Guys, be careful out there if you're out in those areas. It sounds like it's still not done, so be careful out there, chat. In the meantime, good night, and I will see you guys in the morning.
Blacksmithing and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show. blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show. Weapons, blacksmithing, and models of planes,